So Molly, some holidays are quickly approaching and some parents have been asking whether their existing child arrangements order still applies after school has broken up and can they take their children abroad?
So to that, I would say child arrangements orders often have provision for contact over the summer holidays and sometimes provision for that child to go abroad with one of the parents. This is something that we particularly like to include in child arrangements orders, so it means that once the summer holidays come around, there's an agreement and a level of certainty as to what is happening and the parents can plan accordingly. In terms of taking the children abroad, if there has been previous proceedings or there's a consent order in place with a lives with element, which means that the child lives with one particular parent, then that parent can take the child out of the country for a period of up to 28 days. If there's no previous proceedings and there's no order in place, then both parents will need to agree to that child going abroad, even if the child does not live with the other parent. So what we're seeing more frequently is parents getting stopped at the airport and particularly at the border, especially in those cases when the children have a different surname to the parent. Perhaps the mum hasn't got the same name as the children and she's travelling with them, and we've had clients approach us about this issue, and in those circumstances, as well as obtaining the other parent's consent, I would also advise getting that put in some writing by a solicitor, so then when you do go to the border you can present this document to them and essentially not have any issues and have a smooth sailing rest of your holiday.
So it's not always necessary to have a child arrangements order, but what if parents can't agree on what happens over the summer holidays? What can they do?
So if parents have tried speaking to one another and that's proved unsuccessful, then we would advise getting some legal advice in that regard. So the first step with respect to proceedings is for the parties to attend mediation. Now this isn't always appropriate, and if the parties' views are completely polarised, then it's not necessarily going to be successful. If it breaks down, then we can make an application to the court. Before we do make an application, we would try and sort arrangements for children through correspondence in the first instance, as this tends to be quicker and more cost effective than issuing court proceedings, but proceedings there if necessary.
For those parents that do have a child arrangements order, how often should those orders be reviewed? Is there any timescales that they should be looking at?
So I would say that it depends on the circumstances. Every case is different and there's not necessarily a timescale or anything that needs to be where orders should be reviewed. What I would say is some orders that are old can lose relevancy over time. So an order that was made when a child was 3 years old is not going to be suitable or relevant when a child reaches 8, 9, 10 years old. So in those circumstances, if matters aren't agreed, then I would advise that order to be reviewed and potentially by consent another order being put in place. I'll say a short conversation with a solicitor can clarify whether a variation is appropriate in your circumstances, but of course it varies from case to case.